Hey there, Jesse Moore, Pickett Street Properties.
Fred Boskus, Pickett Street Properties.
So Fred, I often tell short sellers that I am not two things. I am not a CPA and I'm not an attorney. And as I start this video, I want to say that I'm not a state legislature guy either, because we want to talk today about House Bill 2614, which was passed by the Senate, Washington State Senate, March 5th of 2012. This is in May of 2012. We're going to be discussing this and ramifications for borrowers considering a short sale or approaching foreclosure.
And part of the reason we're bringing it up is that it was passed in March, but it actually goes into effect next month.
Yeah, so there's some, you know what, I don't find most bills interesting reads, but you know what, there is some interesting things in this. So the primary thing that I think most realtors will pick up on, and this has already been like kind of bulleted to us through the Northwest MLS as well, is that borrowers have to disclose whether or not they're going to pursue a deficiency against the borrower.
Right.
Which I think is interesting because it doesn't clearly state, if I'm the borrower, wouldn't I just say that I'm going to pursue a deficiency?
Sure, leave your options open.
Yeah, I mean, because the way that this reads, it basically says that they have to do that in the first notice to the borrower. This isn't in the letter. It doesn't spell it out that it has to be in the letter of approval.
Right, and this is not at the end of the short sale process. This is a lot of times even before it's even begun.
I just think it would have been, I think it would have had this would have been a heavier sword if it would have said, if they agree to, if the mortgagee, if they agree to a workout solution, that they then have to say whether or not they're pursuing a deficiency. So anyway, that's step one. Step one, banks now have to disclose whether or not they're going to pursue a deficiency in their first notice to the borrower. So the good news is that we now have a little bit more information when working on a short sale, when our borrowers get a notice from the bank. All right, the other thing that I thought was interesting is there's a small clause, it's like only 5 lines long, that basically clarifies that if you are short selling your home and you have gone through a bankruptcy where those liens have been discharged, or those notes have been discharged, and the liens still exist on the property, basically clarifying, saying that just because you are pursuing a short sale, it doesn't renew the deficiency rights for the banks. Right? Is there an easier way to explain that?
Basically, you're not it doesn't mean that you've reaffirmed the debt.
Right, exactly. So if you've if you're considering a short sale and then you're like, well, I've declared bankruptcy, they can't come after me anyway for a deficient balance, that's great. Those liens are still on the property, you still have to get rid of those liens. And so basically, Washington State is making it clear to those banks and saying, hey, in cases where this debt has been discharged through a bankruptcy, if you agree to a short sale workout, or if the borrower agrees to a short sale, it's not renewing any deficiency rights on those notes.
And I actually talked to someone last week that could have benefited from that if this had been enacted sooner.
All right. I think this is probably the biggest thing, is that this bill also shortens the time frames for the pursuit of deficient balances. In Washington State, prior to this bill, banks had 6 years to pursue a deficient balance. So what I mean by that is if you had a second position loan and you were foreclosed on, or if you, well, let's just use that for simplicity's sake. You have a second position loan, either a HELOC or a purchase money second. Let's say it's $100,000. The first mortgage forecloses on the house, and that second mortgage gets nothing. They then had 6 years to pursue the balance of that debt from the borrower personally. I could get into some other things. They could actually apply for extensions twice for 10 years, so it could be up to 26 years. This new bill shortens that time frame pretty emphatically to 3 years.
3 years from the date of agreement.
So, I mean, that's good news. The good news is that if you get foreclosed on, or if you agree to a short sale that has a deficient balance, they can only pursue that balance for 3 years instead of 6.
And they have to go to court to initiate the process. They can't just start calling you out of the blue.
Oh, they'll call you.
Of course they'll call you, but I mean, to legally go after it, they have to go to the court.
Right. And then the last thing, that this is the most interesting part to me, because I really want to have this explained to me. And we'll probably do another video on this next week, because I'm going to get clarification on this clause from a lawyer tomorrow. But near the end of this bill, there's a statement basically saying that, well, let me read it. Up to the 11th day following the trustee's sale, the trustee, beneficiary, or authorized agent for the beneficiary may declare the trustee's sale and trustee's deed void for the following reasons. So this is important to us because we help people buy homes at trustee sale.
Right.
And so essentially, what's kind of fun about the trustee sale is there's an element of risk to these sales for sure. But one of the things that's kind of nice is that it's hard to unring this bell. I mean, once the property's been sold at trustee sale, it's really, really hard to unwind that. And so buyers can buy properties there with some certainty that they will get the property.
There's no right of rescission for the previous owner.
Right.
Once once a sale is declared, then that's it.
So what's interesting is that here it opens the door a little bit, and it says basically if there was an erroneous opening bid made by or on behalf of the foreclosing beneficiary at the trustee sale, then and the borrower can prove that in some way, then they can unwind the trustee sale within the first 11 days following the sale. Here's the clause that I'm wondering about. It also says that if the borrower had agreed prior to the trustee sale to a loan modification agreement, forbearance plan, shared appreciation mortgage, or other, here's the key, or other loss mitigation agreement to postpone or discontinue the trustee sale, then they can unwind the trustee sale.
Right.
Now, I think what can be seen here, what should be emphasized here or clarified, is what's the other loss mitigation agreement?
It's hard to say, and half of this bill deals with the mediation process that's available, and
But here's
it's incredibly
what I think
complicated.
of when I hear other loss mitigation agreement.
Mm-hmm.
Short sale.
True.
That's a loss mitigation agreement.
True.
So if we have a seller that is pursuing a short sale, right? We're under contract with the
Right.
buyer. We're pursuing a short sale. I think I can unwind that trustee sale.
It'd be interesting to see what happens with that if there's a legal precedent.
And so I think this language is a little ambiguous, and I think it could be problematic. But if I think it's interesting for short sellers that if your property goes to auction, this may be a new bargaining chip for us to say, well, on House Bill
2614.
Section 13, Clause 2A,
Line 16 of page.
this says that we can unwind the trustee sale because we're in a short sale agreement.
Right.
And so we can just call the trustee and say, I hope you're not going to foreclose on this property because of this, and we can fax this to them. So, this is a little ambiguous, but here's the thing that we want you to know regarding House Bill 2614 from Washington State, is that it does clarify some terms of the short sale process in Washington State, and banks are going to have to deal with this.
Right.
And I think the three big things is that banks have to disclose deficiency pursuit on the liens if they're doing any sort of workout arrangement. The shortened time frame for pursuing the deficient balance to 3 years,
Right.
and then perhaps prohibiting foreclosure on short sale listings.
It's going to be interesting to see what happens, and I'm sure that there will be legal challenges to that.
So we'll post follow-up videos to this, this is 40.
5-6 pages, something like that.
It's 43 pages long, which is pretty short for a bill. Good on ya, Washington State Legislature. and a lot of this is redaction and restipulation, and a lot of it involves other things like mediation process and notice of trustee sale overall. But these are the big points that we wanted to talk to you about today. And if you're thinking about a short sale in Washington State, we just wanted to kind of bring up what this House Bill 2614 might mean for you. So we'll talk more about this on a later date. But thanks for listening for now.
Thanks.